Should the temporary foreign worker program be terminated? Employer considerations given the high volume of undocumented workers, and new challenges in SUV work permits and strategies on this edition of ImmPulse.
I'm Howard Greenberg.
Hi, I'm Hameed.
I guess in starting today's session, I should remind you, we only do this for about 5 minutes today. The topics you raise can be discussed for hours.
True.
So we'll see if we can compress it a bit.
Right.
Where do you want to start?
Well, we see a lot of public information discussions, conservative leader talking about closing down or terminating the temporary foreign worker program.
So we've seen this before.
We've seen this before. We also know that there's a lot of concerns about having to reduce the total number of temporary foreign workers in Canada because of housing and other issues. And so one of the strategies is to pick on certain programs and suggest that that may be an effective way of reducing the volume. Now, what I would like to hear your thoughts on it. I have my own views.
Well, my thoughts are that this is all well and good to discuss ad nauseum in media, especially this last weekend's newspaper. But the reality is nothing substantial is going to happen. There aren't going to be any major restrictions because there are key resources coming to Canada, and our Prime Minister wants to make us globally competitive. And we're not going to be doing that if we close up our doors, our borders. So I believe that this is an interesting discussion. It's kind of sexy from a political point of view, but the reality is there are workers coming under these programs that are badly needed.
Correct. I agree. I think this will go nowhere. I think in the past where we saw improvement was enhanced compliance, better processing, more integrity. I think those are good measures, but simply closing a program down doesn't make sense. Many of our clients, when we look at the recruitment efforts, it's clear there's labor shortages, prolonged labor shortages, and many of these work permit holders are critical to the success of really important engagements.
So if I was a company thinking about opening up operations in Canada, there's a lot of different categories for getting work permits for their key employees. I wouldn't pay much attention to this. I wouldn't let this discussion influence an expansion or an establishment in Canada.
Right. Yeah. I think there's a difference between operations and the political discussion.
Absolutely. So now that we've put foreign workers aside a moment, or at least a policy, there is something I want to inject in this conversation. It's not in this week's ImmPulse, but it's certainly worth noting if you're an employer in Canada, and that's your obligations for compliance. I can't see any real discussions that have arisen amongst my colleagues or in the employment marketplace about employer obligations, but maybe we can spend a few minutes and talk about them. There is an obligation on an employer to ensure that the individual who is presenting themselves for a job has the status in Canada to be lawfully employed. And we may not have had that discussion 2 or 3 years ago. We set up lots of compliance regimes for our clients, but they've never really talked to us about it in detail. But today, what we find is that that the government intends to reduce the number of temporary workers in Canada or temporary residents. There will be a reduction in the number of PR applicants in Canada, substantial, and that there are hundreds of thousands of workers or residents on temporary status who may not want to go when their status expires and the IRCC doesn't extend their status. And so the next question is, what should employers be concerned about? And what I'm simply saying at this stage is, employers beware.
Right.
Because they better ensure that the individuals presenting themselves to them have proper open work permits, have a study permit that permits a certain number of hours of work per week, or are business visitors that are lawfully engaging in those activities with the employer. There are a couple of different inquiries that employers must make and satisfy themselves, and I mean overtly satisfy themselves, put documentation in the file, ask the questions, and keep notes.
So there's a higher obligation on employers in today's climate. In the past, we saw many younger graduates would come in and they would find a pathway for PR. But that can't be assumed anymore. You could have an individual with 1 year of work permit authorization left, but there's no guarantee that they're going to become a permanent resident. So you as an employer would need to appreciate Is this someone that you're going to take on? Would you support them? Do you have a policy that supports individuals' transitions? Would you get an LMIA? Or do you take a different approach when you're onboarding? And that involves recruitment, legal, and HR all thinking along the same lines, having a policy and an action plan.
So there's an ongoing obligation on employers to make sure that they have a compliance-sensitive regime in place, a file folder for the employee, documentation to show how the employee was initially engaged, and what reviews of documentation, status documentation were undertaken, how the employer is ensuring that the status remains in effect throughout the term of the employment, and keeping those records intact for 6 years after the employment in case someone comes a calling.
Right.
I think those are compliance regimes that Canadian employers must think carefully about now.
Right. And I think in some discussions with employers, we've noticed that they haven't done a refresh since the time of COVID to make sure that your policies, your flexible remote work arrangements, is everything lined up with the current trend with policy operational direction. So it's a good time for a refresh.
And I would mention that refresh would include looking at all of the current foreign workers, that they're on proper status in a document that hasn't expired.
Right.
I'll tell you, I received a call from a client the other day, and she said that she's actually been losing sleep because one of her foreign workers, when they took a closer look at the status document, weren't satisfied that she was under a document that actually permitted employment. Right. Or continued employment. And her question simply was, am I in trouble? And the legal response to that wasn't a very satisfactory one to her.
Right.
Which caused me to believe that no one's really turned their mind to where these 700,000 plus or minus temporary residents are going to end up. And once they don't leave Canada, but they still seek employment to feed themselves. And no one's come up with the answer as to, we're not going to let them stay and keep within the parameters that the Prime Minister has designed for temporary residences in relation to the total population. So where are they going to go?
Right. And the immigration laws and penalties are clear that an employer has an obligation to ensure somebody has proper work authorization before they're employed. So there's consequences.
Employer beware.
Beware. Why don't we switch to the last topic, which has become very trending, is we've discussed in the last edition of ImmPulse that refusal rates across the board, PR and work permits for the SUV program, have gone up very heavily. And we've seen one specific trend recently where work permits for the SUV program have been challenged on the issue of whether there's a significant economic benefit.
Whatever that means. So we know that there's the old C10 Regulation 205 significant benefit. It was to be economic, cultural, social benefits. How that translates over to a benefits argument in the SUV program is entirely unclear. And the decisions that we've been reading by officers have got us scratching our heads as to what they were looking at and what rules they were following. So that makes application for a work permit in the SUV program precarious. And look, the one question I can't get past is, if you can get an open work permit in the SUV program, meaning you can work for someone else, then how do you demonstrate significant benefits to get the open work permit where you're not even going to be employed full-time in the program that you theoretically authorize the work permit?
Right.
I don't understand.
Well, look, the work permit, optional work permit, was introduced as a stopgap because of long processing. The policy changed, but you're right. Some of the underpinnings are questionable. You also have to be responsible for the content in the certificate. We see officers are looking behind the certificate. They're looking at your submission. They're looking at your business plan.
Right.
You know, your product innovation. You're creating jobs. There's a lot to it. A lot more than what was anticipated. So this will be an area, I think, of litigation and a lot of need for preparation to get this right.
It's only the beginning.
Right.
If you have any questions about the topics we discussed today, we'd be pleased to discuss them further with you. Please reach out. Thank you.
Should the temporary foreign worker be... Should the temporary foreign
What?
worker...
That's not how you start, is it? Well, what if they hang up before the end? They won't even know why.
Oh, this is a pretty dramatic intro.
Okay, go ahead.
Thank you.
Who are you thinking?
You.
Oh,
Say thank you, Douglas.
you're welcome.
Anytime.